This meeting will now come to order. Welcome to the April 22nd, 2024 City of Asheville Board of Adjustment meeting. My name is Suzanne Godsey, and I am chair of this board. The Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statutes and the city's Unified Development Ordinance, also known as the UDO. We are authorized to hear requests for variances, appeals from final determinations made by city officials, city officials charged with enforcement of the city's UDO, requests for reasonable accommodations, and other requests as may be provided in the city's ordinances. Our first agenda item is the review and adoption of the minutes of the February 26, 2024 regular meeting. Has everybody had a chance to review those minutes?
Yes.
Is there a motion?
A motion to accept.
Can I get a second?
A second.
Thank you. All in favor, say aye.
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 Great. We now begin the evidentiary hearings for the cases listed on the agenda. In hearing cases, the board conducts a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. These rules are different from some other types of land use decisions, like rezoning cases, which are legislative in nature. This board's decisions are constrained by the standards in the city's ordinance and the facts presented at the hearing. The board hears and considers evidence presented at the hearing and applies the standards set forth in state law and the city's ordinance. The board must base its decision upon competent material and substantial evidence presented at the hearing. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. Participation is limited. This meeting is open to the public. Everyone is welcome to watch. Parties have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Witnesses may testify as to the facts to which they are competent to testify, so long as those facts relate to the legal standards. In addition, lay or non-expert witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts on traffic safety. For variance requests, a 4/5 vote of the board is required to grant the variance. For all other hearings and matters, including the adoption of the minutes, the decision will be made by a simple majority of the vote. Witnesses must swear or affirm their testimony, and at this time, we will administer the oath for all individuals who intend to provide witness testimony. Please stand and raise your right hand if you plan to provide testimony. Do you solemnly swear or affirm that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Okay, our first case today is a variance. The petitioner, Dean Clayton of Blue Ridge RX Holdings, LLC, is requesting variances to the setback standards in Section 7816F4, Highway Business District Lot Width Standards, Section 7816F5, Highway Business District Setbacks, Section 7112K, General Requirement for Access to Streets for Non-Residential Lots, and 7151I, Subdivision Standards of the Unified Development Ordinance. The applicant is seeking relief from the required front setback from 35 feet to 23 feet and lot width of 100 feet to 26 feet. And the property is known as 1070 Tunnel Road with a PIN number of 9668271378. Nancy Wadford, zoning supervisor, will be presenting.
Madam Chair, I'll give a quick introduction first. There's a
You may.
anomalous amount of attorneys in the room today, so I just wanted to
Yes.
explain who everybody is. There's an appeal that is next on your agenda, and so for that reason, we bring in Mr. Ron Sneed to
Yes.
advise the board, so that we have unaffiliated counsel here. That's who you should direct any questions you may have to. In the first variance, the applicant is represented by Mr. Craig Justice. He is here. The variance that's before you is coming somewhat at the city's request. We had a question about whether we could require the improvement of a road in relation to the subdivision. Not sure that we're on legally solid ground there, and so rather than have any sort of litigation about that, we've asked the applicant to come here for a variance request, which the city supports, but he'll present the substance of the case. But that's who everyone is and who you should expect to hear from.
Thank you. All right, Mrs. Watford.
Okay, well, good afternoon, Chair and Board. First correction is that the lot width is from 100 feet to 0 feet. It's that in their application, it was a little confusing in the way that it read because the right-of-way width averages 26 feet. And even at that point, it narrows down even further than that in a lot of cases, in many places. So, they do have, well, I'll get there. So as that was just read, and this one is corrected, that the lot frontage and corresponding lot, or the lot width and corresponding lot frontage is changed from 100 feet to 0 feet from the highway business lot district standards, setback standards, that one's gonna be straightforward, and general requirement for access to streets for non-residential lots, and then our subdivision standards. Part of this is, so I'll walk you through, these are the different variances, but the setback standard is a reduction of 12 feet due to the placement of the building on the existing site. And then the access for requirements for all lots, that's one. And then the conformance with all the other regulations is because they're basically creating a new lot, which a lot of times when you have a major subdivision, you're creating a new lot and dedicating a road and right of way that the developer or owner has control over. And in this case, they don't really have that because the North Road is in a publicly dedicated right-of-way. And in most cases, when we have commercial lots that want to subdivide off a building or a piece of the property, and it doesn't meet the current frontage that's required for that zoning district, they can choose this option, which allows them to do an easement. And this one is kind of, it's not really a variance because they can't meet it. And that's because North Road, I think I'm saying that right, is in a publicly dedicated right-of-way, even though it is a privately maintained road.
Can you say that again?
So North Road is a privately maintained road and has served access to this warehouse as well as some adjacent warehouses across the street, but it's in a publicly dedicated right-of-way. So it's not under city street maintenance.
Private road, public.
Mm-hmm. So they can't dedicate an easement to themselves through a public right-of-way, even though it functionally serves that same purpose. So this is the site. It's 1070 Tunnel Road. And then it's in the highway business zoning district. As you can see, there's highway business surrounding a majority of it, except for a RM6 to the north and a little bit to, let's see, there's about 191 feet of RM6 on the eastern property line. Currently, there's 2 buildings on the site. The front one is a retail warehouse that was built in 1984. And then the rear building, which is approximately 22,000 square feet, is a warehouse that was also built in 1984. The applicant is seeking to subdivide the parcel into 2 parcels with 1 building on each parcel, so that the rear building can be sold with the associated land. North Road, yes,
The rear building to be sold with?
with land, with the associated land around it. Instead of, this is really hard to see, instead of a situation like in the adjacent where there's red property lines around the building, which indicates that that is sort of like a condo lot, where that's the building ownership, not necessarily the land. I'm not sure in that case, but they want it to go with the associated land and parking and loading bays, et cetera. That's, so North Road is a long time dedicated private road within a public right-of-way. And that right-of-way ranges from 26 to about 19 feet. So even in so for our frontage standards, you have to build a road to city standard or a modified city standard within the publicly dedicated right-of-way of a minimum width of 20 feet. So here you cannot physically build the road in the right-of-way because the right-of-way is less than 20 feet. And that is the same for, it does pinch down to the north since there are lots that this serves to the north, and it pinches down to even I think 12 or 8 feet eventually. And so all of those lots to the north that are residential would be considered legal non-conforming lots because they're kind of in the same situation where they can't provide that road and dedicate the right-of-way because they don't have control over it. Nor does an entity that has right-of-way dedication. Right-of-way encumbrance. I got that word wrong, but anyway. This is the site as you enter in off Tunnel Road. And that's as you cross, that's the front building on North Road. And then this is the rear building that they want to subdivide off with the loading docks and associated parking areas. And then the gravel roads continue up to the residential sites behind it that have yet to be developed. And that's a closer look. This is their proposed subdivision. And then here's the existing encroachments for the setback variance, going down to 23 feet. The surveyor didn't measure it. When I measured it, it was 24, but I'm going with what the surveyor provided because we know that Bluebeam isn't as accurate as the surveyor's information. But this is the building encroaches this close to the property line, and the subdivision would switch where those front setbacks are. So the front setback, which is now on Tunnel Road, would move to North Road, that's why this is an existing encroachment that we would support the variance on. So this is just descriptions of the right-of-way, and that there is 20 feet of pavement paved for at least over 100 feet. Just not all of it is in the actual right-of-way. And the right-of-way is narrower than 20 feet, so that's why staff would also support the variance because it's functionally there. And that is all I have for you. Any questions for me?
Any questions, board?
You third?
I've got
Yes.
a question. Yeah, I'm just trying to get a feel for, so the purpose is to be able to sell the back property.
Mm-hmm.
And when you look at going down, approaching the second or the back property, that where it narrows, are you still able to get two-way traffic in
Up in,
It's like they have heavy truck traffic.
yes. Yeah, that's actually where, so it's 19.8 in the right-of-way, but if there's no area where they have dedicated, like nobody parks right in there, so they could have two-way traffic.
Any other questions? Okay. Do the applicants have a presentation or testimony for the board to consider?
Good afternoon, Madam Chairman, members of the board. My name is Craig Justice. I have been sworn in. I'm here together with Chris Day, who has also been sworn in. We're going to try to keep this fairly simplified. I do have two documents that you can read. You don't have to read, but this sort of summarizes what we're going to say to you. So this is an affidavit that Mr. Day had prepared. Is that a copy of your affidavit?
Yes.
All right. So, Madam Chairman, I would like to just go ahead and turn this in, pass this around, and I have prepared an affidavit as well. This is Exhibit 2. So if I can pass these documents around, procedurally let the clerk have the original, and then we can move on to an oral presentation. Is that okay? Yes. All right, thank you.
Thanks.
I have a nice big blow-up from Hinko's to help explain the situation. So I'm going to turn it over to Chris to give you some of the background information, and then I'll supplement that when he's finished.
Slide over a little bit. Thank you. My name's Chris Day. I'm with Civil Design Concepts. I really want to thank Nancy and staff because this is kind of a unique and confusing situation. I've worked in Asheville as a professional engineer for the last 18 years, and lately I keep finding more and more of these scenarios where we've got some type of an adaptive reuse or existing buildings, and we're trying to apply a code that is more built for brand new development. And we just keep running into these little issues. And this one is something that's even more unique, but it's something that's really simple, big picture, but the code is making it really complex. So the simple part of this is it's an existing warehouse on North Road. I'm going to go with Nancy's pronunciation there. On North Road, and as she said, they've been, both the office building in the front and the warehouse in the back have been there for almost 40 years. And they only have access from North Road. So my first thought had been to use that 711-2K where it's subdivisions for non-residential lots as we started running into some of these issues, but I didn't even think about what Nancy said. I thought the confusion was, I was like, oh, we've got 20 foot of pavement, and we do have from the DOT intersection, so this is US 70 Tunnel Road and Swannanoa River Road are both NCDOT roads, and a signalized intersection, and we have signal heads that come onto North Road and come back this way. So and we have at least 20 feet of pavement within the right-of-way from the intersection, the DOT signal, all the way back to at least 100 feet along the warehouse space. At about 100, it actually goes, so it's about 400 feet of 20-foot pavement, and then it turns into the gravel road that you see there. That gravel road continues on about 1,200 more feet, and from my look on GIS and from my site investigation out there, It provides access to about 6 other single-family homes and about 6 other vacant parcels of land. So those 6 homes by the Buncombe County records were built between 1947 and 1967. So the one that you see right there on the right, the tax records show that it was built in 1947. These buildings weren't built until 1984. And so, big picture in the package that Craig had provided, there's some photos in there. I've got a little, not quite as big a blow up here, but in those photos, the first one that I show is the beginning of North Road at the signalized intersection. And I'm looking at the site, and you can see the primary access to the office building as well as the primary, well, in that photo, you see the primary access to the office building. And then you see all of the street trees, sidewalk, and infrastructure that are preventing and have long-standingly there's not been any direct access to Tunnel Road from this property. The pavement width in that photo is all greater than 20 feet in width. That 20 feet in width does comply with 711-2K of having 20 foot of access road. It also complies with North Carolina State Fire Code that says that we have to have a 20 foot wide access road for two-way traffic. The next picture I have is actually taken from North Road looking back towards the traffic signal at the US 70 and Tunnel Road, with the access to the office building right there on the right side of the photo. This photo, as you're looking back to the north and the office building is on your left, there's you can see where the building is only about 2.5 feet off of the existing paved road. And then you can see the warehouse in the background along with the city recycling trash cans that are along North Road here. The fourth picture that I have shows the corner of the building, the existing warehouse, and this is the corner of the building that, that Nancy had kind of labeled in the description. I don't know. Yeah, so this is the corner of the building down there, and she's got it labeled as 24. I had put 23 foot in the application just to kind of cover myself. And in fact, that's to the property line. The right-of-way by the survey, the right-of-way is actually about 18 feet off. So it's that other line, that kind of the dash line that you see there on the paper. But considering North Road as the frontage and the primary access point, under the HB zoning, it requires 35 feet of front setback. And so this building does not have that, and so that's why we're asking for the variance. Once again, big picture, this has been a warehouse for 40 years. We're not proposing to change the use. We're proposing for it to continue. We're just trying to put a subdivision line in there so that that building can be sold separately from the office building up at the front. Based upon my review of it, I feel like that the hardship is just the lack of ability to be able to sell the warehouse on its own parcel, and that the situation is unique as it's been a warehouse for 40 years and we're not proposing to change the use. The hardship did not result from any actions by the property owner, our applicant, and the requested variance is consistent with the spirit and intent of the ordinance, as nothing's really being proposed to change beyond the ownership. So, Craig, and I'm here for any questions as well as if there's anything that Mr. Justice needs me for.
So when this came up where the client had an issue with trying to record a subdivision plat that split this property in two, simply to allow the back to be sold, I, as an attorney, researched law and sent a letter to the city attorney saying the city could not impose these standards on my client. cited various statutes and cases and tried to seem like I knew what I was saying. I included that letter in the affidavit I submitted to you. I do think there is good law out there to suggest what the city is asking should not be legally binding on my folks, in part because when they developed this, as Chris said, you know, rules are often set up for the future and prospective development. We've had something there for 40 years, where the reality of 40 years has been access has always been off this privately maintained road. There is not the ability to have a curb cut directly onto Tunnel Road. There are street trees and sidewalks and all kinds of things blocking, as well as the fact that this building is in front of this building, which makes the back building almost impossible to really have access directly onto Tunnel Road. So anyway, we cited our position on that, and the city came back and said, well, let's try to work it out by going through the variance route. So here we are, trying to avoid a hardship for the city and for us. And I think we're all in agreement that this is a worthy case for a variance. I, in my affidavit, had pointed out that North Road is originated back in the early 1900s when a development entity owned a bunch of property in this area, including this tract in question, and at the time recorded a plat back in the early 1900s that subdivided all of this property and created a private access road through it. And so when Nancy says publicly dedicated, that means there is a recorded plat that shows North Road. It's just the city has chosen not to take it over to turn it into a publicly maintained street. So the right of my clients exists to continue to use North Road. The real estate records show that the right-of-way is approximately 25 feet in width. The survey says 26 feet. The real estate records show 25 feet. As Chris indicated, the paving is within that space, and it is 20 feet or more, which is typically good for city streets. At the end of the day, we are sort of in a box, and we can't get out unless we have a variance from y'all, because we can't meet standards of non-public commercial streets, because we don't have the means to develop the street, because a lot of it is off our property. And so we can meet some of those standards, but not all the standards, like the 30 feet in width that's minimally required. Long story short is, we're not changing the use of this property. We're not changing any conditions of this property, other than we want to be able to subdivide it and sell the back piece. And we need a variance to get there. Thank you.
Thank you, Mr. Justice. Are there any questions for the applicants? Nobody? I do have a couple of questions for Mrs. Wadford. Do you know when the UDO was first adopted?
As the UDO or codes? As the
zoning ordinance that would reflect the highway business zoning district.
1997.
And would you explain, and I think I get what you're saying, if they subdivide, all of a sudden, what was a side setback is now a front setback, and that's why they're asking for the front setback reduction, because it's all of a sudden a front setback because of the subdivision line.
Yes.
Those are all the questions that I have. Anybody else have any questions?
What is this parcel zoned again? Like,
Highway business.
it is, okay, so could the use of that building change in the future? Or will it always have to be a warehouse?
It could change within what was allowable within the highway business zoning district from our table of uses.
Okay.
And I did have one more question. The width along Tunnel Road is how wide, Mr. Day?
At a glance, it's about 100, 110 feet.
having attempted to obtain NCDOT driveway permits, oftentimes 114 feet from another intersection at a signalized intersection could possibly be another hardship you would face. Okay, is there anyone from the public here that would like to give expert testimony or testimony from residents withstanding? Okay. All right, with that, we'll lead it up for discussion. Board? Is there a motion? Any questions, discussion?
No.
No. Do I have a motion?
Motion to approve.
Can I get a second?
I'll second.
Great. Then I will call your name. Please say aye or nay. John Michael Cletus,
Aye.
Annette Wise,
Aye.
Jillian Ballard,
Aye.
Mike Luciano,
Aye.
and Suzanne Godsey is an aye. Variance passed. Our second item on the agenda is an appeal. The petitioner, Christina and Christopher Lewis, appeal a unified development ordinance determination by Amy Deaton, Stormwater Administrator, in a letter that was dated December 12th, 2023. This board seldom hears appeals cases, and so as a reminder, as a board, we will be deciding to reverse, affirm, or modify the decision being appealed from and making any order, requirement, decision, or determination that ought to be made. And with that, City Assistant Attorney Eric Edgerton will be presenting the case.
Yes, Madam Chair. There's pending before you a motion to dismiss that is based on subject matter jurisdiction. Do you all have a copy of that in your packets?
Yes.
Okay.
Says there was motion on
Is that under Lewis' motion?
the, yeah, it says there was motion.
Okay.
And then, yeah, Lewis. Double click. No, there was a motion. The one that says Lewis motion, not the motion. One down, two down. There you go.
Ready?
Yes.
Okay.
Go ahead. Sorry.
So the motion before you is jurisdictional in nature, which means that unless you deny that motion, you can't proceed with the case at all. It's what's called subject matter jurisdiction. It's your ability to even hear a case is what's at issue here. And the reason for that is that there's a doctrine of law that's described in the motion before you all that is referred to as the failure to exhaust administrative remedies. Basically what that means is that where the North Carolina General Assembly has created an administrative remedy that a individual could follow in order to get the relief that they sought, they are obligated to pursue that relief before going to any other subsequent level of court. And so you all may remember this. Actually, I believe, Madam Chair, you may be the only member that was here for the off-the-wagon appeal, where we've had a similar instance where there was an appeal of a decision, but this board had to find that it lacked subject matter jurisdiction because the necessary preconditions to this board being able to hear the case hadn't been satisfied. We're in the exact same situation. It's just a different wrinkle this time. It's not that they failed to comply with the time period restrictions or requirements for bringing an appeal. It's that they didn't go through the procedural hurdle. They didn't jump over each of the procedural hurdles that you have to in the specific instance of appeals related to stormwater and erosion control appeals. So there's a citation to a general statute in the motion before you that says that there's a big exception to the general rule that boards of adjustment hear appeals from staff determinations. And that's specifically for appeals related to stormwater and erosion control appeals. And so there's an explicit statement that this board should not hear those appeals unless a city, for some reason, mandates that under its ordinance. The city of Asheville does not. We have a 3-step process before this board would ever hear such an appeal. First step is that there would be an appeal to the stormwater administrator. And this is in the copy of the ordinance that I just handed to you. It's on page 24. It's the subheading there that's labeled appeals, and it spells out each of the different steps that one would have to go through before an appeal related to erosion control ever got to this body. And so you see there, subsection 3A outlines the appeal to a stormwater administrator. 3B talks about the appeal from the stormwater administrator to the soil erosion stormwater review committee. And then subsection C provides that finally, after those processes had been satisfied, this board would be able to hear the appeal. That's not happened in this case. The appeal was made on the 30th day after the decision was issued directly to this body, not to the stormwater administrator, not to the soil erosion stormwater control board. And so those procedural requirements have not been met. And when that happens under North Carolina case law that's again cited in the motion before you all, this board lacks subject matter jurisdiction and cannot proceed with hearing the case. I expect that there's going to be, it'll be noted by the appellant that the stormwater administrator was the individual who issued the original determination in this case. That doesn't affect the process outlined here. It doesn't alleviate the burden of having to go through that process before coming to this board. I'll hold off on addressing that further until Mr. Lewis has had the chance to make those arguments, but it doesn't alter the fact that this body lacks subject matter jurisdiction and can't hear the instant case because those 2 steps before coming to the Board of Adjustment were not taken, and therefore he has failed to exhaust his administrative remedies. So I'll stop there. I'll let you hear from the appellant first, and then I'll come back up for any additional information that you all may need.
Okay, great. Would the representatives like to come on up?
Yes, thank you. Good afternoon. I'm Christopher Lewis. I'm one of the appellants. One of the things that Mr. Edgerton talked about is something I do want to talk about too. The city in this case is seeking to dismiss for lack of subject matter jurisdiction, which I understand, and there is an actual process in the ordinance that addresses that. It's a multi-step process. This case is a little different than things you would normally get because the city did not take any action to make an administrative decision on the matter at hand until I actually filed a civil lawsuit against the city seeking a writ of mandamus requiring the city to apply the city ordinances to the activity at a neighbor's property that did substantial damage to my house. And so up until I filed that civil case, the city was silent on anything other than not taking any action to address the issue at hand that I had requested clearance from, guidance and explanation from the city for months as to why the city was not doing anything to enforce the ordinances that governed the very activity that was taking place. So then I had to file a civil lawsuit. In response to filing the civil lawsuit, the stormwater administrator issued a letter saying that the city wasn't going to take any action. If you look at the ordinance, the city administrator the stormwater administrator is actually the first level of appeal. The determination on whether the city's going to take any action needs to come from a staff level position. You can then have the right to appeal to the stormwater administrator. Then apparently you have to appeal to another committee before you can appeal to the Board of Adjustment. I arguably was unaware that there was a committee in between. My understanding based upon review of case law was that determinations from writ of mandamus had to come to the Board of Adjustment. So to the extent that the city wants to rely on a procedural issue to say this board doesn't have any jurisdiction, they likewise have failed to follow the very procedure that they are relying on to say this board doesn't have any authority to hear this matter. To the extent that the board were to follow that direction and say there is no ability for us to hear this now, I would request that the board stay this action to allow us to follow the procedure that the city is now holding us to, but not holding themselves to. You can't have it both ways, ladies and gentlemen. If the city wants to follow the procedure, give me the opportunity to follow the procedure, and then if we end up back in front of the board, we end up back in front of the board.
So, Madam Chair, I'll respond to that point, and I'll do so by asking you to just flip back 4 pages in the ordinance that I had in front of you to page 20. We were talking about page 24 before. If you go to page 20, you'll see that the enforcement responsibilities lie with the city's stormwater administrator. That is the individual, it is her office that is tasked with making determinations about the applicability of this ordinance to any given property. If you turn back even further, if you go to the 3rd page of the ordinance, there's a subsection titled Administration, and it provides that stormwater administrator, it's a subsection titled Stormwater Administrator. The city manager shall appoint a stormwater administrator to administer and enforce all provisions of this section. Except as specifically stated, any act authorized by this section to be carried out by the stormwater administrator may be carried out by his or her designee. So I'm referencing both of those portions to explain that there's no error, there's no violation of the city's ordinance by having the stormwater administrator fulfill this specific function that she's tasked with fulfilling under this ordinance. It's also no argument under North Carolina law that because she would be the one to hear an appeal, that you're somehow just excused from following that process. I'm going to hand you all a case that delves on that a little bit. There's a highlighted section. It's in a totally separate context from this zoning matter. But it talks about the exhaustion of administrative remedies issue, and it explains why the argument that I believe Mr. Lewis is making, that it would be futile to have Ms. Deaton review her own decision, why that's not a valid argument in this context. First and foremost, that highlighted section, which is on the 3rd page of the case, explains that in order to argue that it would be futile to explore and try to take advantage of your administrative remedies, that the burden of arguing that it's futile is on the person trying to push forward that argument. That if the appellants in this case wish to argue that it would have been futile for them to appeal Ms. Deaton's decision to Ms. Deaton, they have the burden of establishing that to your level of satisfaction. In arguing that, though, as this court noted, futility cannot be established by a party's prediction or anticipation that whatever the intermediary step would rule against their interests. And so it's not sufficient to say, well, I shouldn't be forced to appeal Ms. Deaton's decision to Ms. Deaton. You cannot just say that I'm unlikely to win, therefore I'm excused from following my administrative remedies. Even if we set that to the side, even if you just grant that, there's still a second intermediary step before we'd ever get to this body. So there's no argument first that there's no obligation to appeal to the stormwater administrator. But even if you accepted that, we still wouldn't be at a position where this board would have subject matter jurisdiction, given that this appeal had not gone through the soil board before reaching you all. So for those reasons, there's nothing, the city's followed its ordinance to the letter. Ms. Deaton is tasked with administrating that specific ordinance. She did so, issued a determination, and the appeal of that determination has not followed the requisite process to be able to be heard by this board. And so that's why we've moved to dismiss this matter, and we believe it must be dismissed because this board doesn't have jurisdiction over the case.
Just briefly. The clear language of the city ordinance addresses the appeal process. And it just, first part is, first level of appeal, with the exception of appealing for the issuance of variance, all appeals must initially be heard by the stormwater administrator, which means the plain reading of that is that the decision has to come from somebody else. The other thing that makes this case different probably than other things is the determination was based upon the allegations in a civil complaint. The allegations in that complaint are beyond the stormwater ordinance as it relates to the writ of mandamus. One of the big issues in this matter is whether the city was required to enforce the permitting process for the work that was being done. The property owners at issue across the street from my house undertook to artificially elevate and modify the slope of their property significantly by depositing 45 plus truckloads of dirt to elevate the height and modify the slope of the property. The permit they sought was to do grading work to put down sod. It was brought to the city's attention that the work being performed was not permitted, because when it started, there was no permit issued. After we had the first issue at our house, they finally applied for a permit, but the permit merely says land disturbance to put down sod. Doesn't say anything about modifying the landscape, elevating, putting in additional fill dirt, anything like that. The city came out after our house was severely damaged and saw the scope of the work that was going on. I inquired to the city, why are they allowed to do this work when this is what the permit says? This is not within the scope of the permit. City didn't do anything. The excuse I got was there's a grading permit. I said, well, dumping 45 truckloads of dirt has nothing to do with grading. That's the only excuse I ever got. They have a grading permit. And so the scope of the project we're talking about here is beyond the scope of the stormwater erosion control ordinance as well, because it just gets to the general permitting issues, whether the work should have been allowed, whether it should have been allowed to proceed based upon what was in the permit, what was actually done, and what the city was on notice of, what was actually occurring. And those don't add up. And that's why this whole thing is where it is today, because of the big question of, is the city going to take any action to require permitting of something that's clearly not permitted, and then just let it go? And so I think that the board does have jurisdiction to hear this matter because it goes beyond the scope of the stormwater ordinance into the general permitting requirements of doing projects within the city limits. But in addition to that, they also didn't meet the requirements of stormwater ordinance, which, as we've talked about, is subject to that appeal process the city hasn't followed. And so I would just renew my request that if the board is inclined to follow the recommendation, you don't have jurisdiction to hear this matter today, to stay it to allow us to do the proper administrative procedure, starting off with requesting a determination from the proper level at the city that we can then appeal to the stormwater administrator, and then up the chain till it gets back to here, so we follow the proper procedure, and we're allowed to have this board of adjustment if ultimately you're the ones to decide whether the actions taken by the City Development Services Department in allowing this project to proceed was appropriate or not.
Thank you, Mr. Lewis. So let's take this one step at a time, which would be to first, I have questions. But is there anyone else that would like to speak on this matter? Or no?
Our position would be that until you decide the motion, it would be.
We stay into this, okay. Now, I don't know if I'm supposed to be asking you, Mr. Sneed, or if I'm gonna be asking Mr. Edgerton, or I'm just gonna be asking out into the world.
I will provide answers to the legal questions as best I can. Some of the factual part, you guys will end up having to parse out. It seems to me that for you to decide on the motion, one thing you do need to know is what is the issue? What is being appealed? And if you can get the attorneys to define that a little bit, I think that's going to help you a lot. I don't know this case but from what I'm reading, I'm not real clear on exactly what decision or lack of decision they're appealing from. And if it was a lack of decision, whether it was a stormwater decision.
But I thought first we should decide whether or not we should be hearing this case at all.
That's correct, but you ready for a history lesson? 99% of all administrative decisions come directly to you. There are a few situations where the legislature and the UDO will provide that somebody else will hear those first appeals, and typically those are technical fields. You may be aware of the fact that if I'm the building inspector and I turn down some work you've had done, you want to appeal it. It doesn't come to you, it goes to the insurance commission. So there, in some technical areas, there are other places to go. Might end up with you, but it goes there first. The other issue that was tossed out there is it makes for a decision to go to the stormwater manager or administrator. Then he says it's implied that some other administrator should have made a decision to appeal to her. For comparison, code enforcement, for instance, if the code enforcement officer, the city goes out to my building and says it's unsafe, you gotta fix it or tear it down. My first level of appeal is to that code enforcement officer. Then it goes up the chain. And so that's not a real unusual situation that the stormwater administrator says, you gotta do this, or I can't do that, whatever. And then that same person hears the appeal. That doesn't invalidate the process. It doesn't imply that somebody besides the stormwater administrator should have made the decision that's appealed to her. And I don't know that helps you a lot, the big picture here, but just those little procedural steps are not unusual. They are found in different areas of the UDO and different people's ordinances. So the reason I was asking, this is the argument made by the city, is that this was a stormwater decision. That stormwater decision had to be appealed to the administrator, then to the erosion control folks, then to you. If it was, and I don't know what the decision or lack of decision was, sitting here with you, wondering what they're appealing from. And if somebody could define that for you, is it a stormwater issue that's being appealed from? I think you could more readily think about this appeals process the city says they should have followed.
I have a quick question too. Are we allowed, so does it make sense as our options go? Is a stay the only option, or would be dismissing it without prejudice be an option? So that you can bring it if it were to come to us again?
If it comes to you again, it'll have to come through the proper channel in the proper way. You don't have the ability to stay it. If you have no jurisdiction,
Right.
you don't have the jurisdiction.
Okay,
to
it would
do
just be
anything.
dismissing it, doesn't matter prejudice,
Well,
no
and
prejudice,
again,
it's just dismissing it.
you're dismissing it not on the facts, not on the validity of the claims, but on the fact you don't have jurisdiction. And when you don't have jurisdiction, you can't stay it,
Right.
you can't
Okay.
dismiss it with or without
He
prejudice.
still has the
You're
ability
just
to go
saying,
back and do what he
we
needs to
just,
do.
we just
and come
can't
back.
take it on.
Got it, okay.
If I can jump in and echo on the point of if somebody could define what the appeal is, fortunately, that all happens when you guys get an appeal. We have a form for that, and so the form in front of you all in the record allowed the appellant to define the ordinance section that they were appealing from. You will note that it is the stormwater ordinance that you have in front of you, 712.2. Marked at the top of the front page of the appeal form, it's related to 712.2, referenced. I'm not going to be able to count the number of instances, but it's 712.2. So there's a stormwater appeal before you, and there is a conclusive evidence that the process wasn't followed in order to get that appeal to you all.
I'm going to take a look at this just
Just briefly, yeah, we did make reference to that, but there's also reference in here to the fact that the city of Asheville didn't follow their own inspection procedures when it came to the issuance of the permit and everything of all the work being done out there. And I will look in here to in the section on the second page, it says, we also are alleging that the property owners were in violation of the permitting requirements for land disturbing activity as stated on the permit issued by the city of Asheville, because the work that they were doing was not in compliance with what they asked the city to allow them to do.
Okay, so at this point, I think that the board needs to have a discussion on what their thoughts are at this point in time. Thoughts?
Dismiss.
Okay, so we've had a little brief discussion up here, and I think that someone may make a motion to,
Motion to dismiss.
do I get a second?
Second.
Okay, when I say your name, please say aye or nay. Annette Wise? Jillian Ballard?
Aye.
Mike Luciano?
Aye.
John Michael Cletus?
Aye.
Suzanne Godsey is an aye.
Madam Chair, I prepared an order to that effect. Your signature on the second page.
Thank you. Can you grab your pen?
Oh, sure.
Okay, so that's it for our case today, our cases today. If there are no objections, we will adjourn the meeting. Are there any objections? Okay, this meeting is adjourned.